the respondent. With your permission, my lord, permit me also to refer to my lord's first, if I may seek your indulgence. Yesterday I was meant to apply to have our bundle of authorities admitted, which was not done because of the circumstances of yesterday. May you permit me in this junction to pray that you permit the authorities that we presented, the band of authorities that we presented yesterday, and these were 6. Together with an addition. My lords, with your permission, with just one additional authority.
Applicant's index of authority.
Yes, my lord. It is 5 on 4th, which was yes.
Lord Attorney General, what's the view from the respondents?
My lord, with just one additional rules authority.
No, but just had you served them? When you find it, did you serve the respondents?
Yes, my lord, we did.
Right.
Yesterday.
Yes, my lord. We were served yesterday, and we have no objection.
No, no. So I suppose. Mr. Lubega, is it contained in this?
No, my lord. It is not contained.
How does it look like?
It looks like this, my lord. I don't know if you see. Yes. It is not on your record, my lord.
Oh, it's not on the record?
This one is not on your record.
Oh, you intend to file, to submit another one?
Yes, my lord. Just one.
But you did not avail them?
No, my lord, because this is an authority we picked this morning.
Yeah,
but we are happy to serve them.
No. You see, Mr. Lubega, you know, the moment you get an authority, you don't need leave of court. The first thing to do is to avail the other side. Even if court were to refuse, at least you've been gracious enough to avail the other side. Then they have something to say.
My lord, I receive your guidance with gratitude. Thank you.
Oh, I don't know what you say. I have not seen the authority. You've not seen the authority.
Does the passport applicant intend now to serve us right now? Yes, then we
yes, my lord.
If
is it a Ugandan authority? Or?
It is a Ugandan authority, my lord.
Okay.
Yes, we will be ready to
and one of the parties is Attorney General himself.
Fine. The court will receive it, but please.
Serve us.
The proper procedure is when you get it, the first people to receive should be the other side. It makes it easier for you to pursue it forward.
We thank you, my lord.
The only difficulty, Mr. Lubega, is that document has not been roasted, so the lordship should not receive it. You understand what I mean?
I appreciate it.
And I think for the good of the other side,
yes, my lord.
We've taken note of it.
Yes, my lord.
I don't think it's safe for counsel on the other side to.
My lord, yes, I appreciate
I'll
it.
make arrangement with my registry to take it for roasting, and then.
Thank you, my
lord. Receive it. Roasting means it's taken in the oven to ensure that you minimize the risk of COVID-19. which is very real.
It is real, my lord, yes. May I therefore proceed?
Yeah, proceed.
Thank you, my lord. My lords, having made reference to the Act and to the...
You've used 10 minutes
Thank you, my lord.
of your time. Yeah.
Having used 10 minutes and left with 10, and I'll try to summarize.
What
The-
about the authority? What are we supposed to do? You haven't mentioned it. What are we supposed to do with the authority which has been taken seriously?
Oh, my lord, I believe by the time I get to it, they would have finished the ovening and the warming of the document. But in the meantime, if you permit, I'll proceed to the authorities submitted yesterday. My lords, we submit that this court should find a pleasure in ordering each party to bear its costs. And the reason is that an election petition of this nature is a very important instrument of guaranteeing the safety of Ugandans in terms of democracy and rule of law. Persons aggrieved by decisions of the second respondent declaring a winner or purported winner of an election should exercise one option, which is the civil option of coming to court. The alternative to coming to court has been and has proved catastrophic in our history, and that is well represented in the preamble to our Constitution. Persons aggrieved and dissatisfied should find the route smooth to access courts of law as the final and ultimate arbiter. Only then shall Ugandans be safe and tranquility be guaranteed. This court has had occasion to consider issues of election petitions and costs in the previous 3 presidential petitions that have been presented. Beginning with authority number 1 in our bundle, which is Kizza Besigye versus Museveni Yoweri Kaguta, now Tibuhaburwa, and the Electoral Commission, Presidential Election Petition number 1 of 2001. My lord, whereas there was no withdrawal in that case, and the petition was prosecuted to conclusion, this is what court had to say, and we have proceeded to highlight the relevant extracts considering the volumes for court. In particular, I'm referring to the judgment of Odoki CJ as it then was at page 8 of that bundle of authorities, page 8 to 9. But one important aspect that comes out...
Councillor Bego,
Yes, my lord.
can't be right to say Dr. CJ as it then was. He didn't attain any other thing in the judiciary after that.
Oh.
So he remains Odoki CJ.
Odoki CJ, thank you, my lord.
For instance, if you're referring to me for a decision I made when I was DCJ, that's when you say DCJ as it then was.
Most obliged.
Because I attained something else after that.
Most obliged, my lord. I was only being misled by, it could have been a misapprehension that thereafter I became a justice of the Supreme Court after being a CJ in an acting capacity, but I'm properly guided, my lord. With that guidance, my lord, at page 8 of that bundle of authorities, we have to say this. It is well settled that costs follow the event unless the court orders otherwise for good reason. And that's where I come to discretion of this honorable court. The discretion accorded to court to deny successful party costs of litigation must be exercised judicially and for a good cause. Costs are an indemnity to compensate the successful litigant the expenses to be punitive, but the successful litigant may be deprived of costs only in exceptional circumstances. In awarding costs, courts must balance the principle that justice must take its course by compensating a successful litigant against the principle of not discouraging poor litigants from accessing justice through the award of exorbitant costs. In the present petition, I am of the considered opinion that the interests of justice require that court exercises its discretion not to award costs to the respondents. I agree with Mr. Valikutemi that this was a historic and unprecedented case in which a presidential candidate, who is a serving president, and I emphasize, was taken to court to challenge his election. The petition raises important legal issues which are crucial to the political and constitutional development of the country. In a sense, it can be looked at as public interest litigation. It promotes the culture of peaceful resolution of disputes. The petition was not frivolous or vexatious, as the petitioner succeeded in issue 1 and 2. The petition was therefore of great public importance. He made reference to others, but I will run to the other justices who, in similar terms, ordered that the petitioner would not pay costs. Of particular importance, by others, is the decision of Oda JSC, A.H. Oda JSC, page 13 of the band. And I will only quote one paragraph that I find very crucial. Second, access to court for peaceful settlement of constitutional, political, and election disputes should be available to all, the rich and the poor, which prohibitive costs of litigation would discourage effective. All the justices of the Supreme Court held in similar terms with respect to Justice Sekoko JSC at pages 16 to 18 of that bundle of authorities who are speaking in similar terms. Our Lords, the Honorable Justice Karokora JSC.
I'm giving you 5 more minutes.
Thank you.
You had eaten of your time, but I know
Thank you.
there were interruptions.
So
Please make sure you conclude.
At page 22, my Lord Justice Karokora JSC to 24 speaks in the same terms. And Mulenga JSC at page 27 to 29 and 28 speaks in the same terms. The ratio in this, my lords, is that a person aggrieved should have nowhere else to run. And that person must not be scared of the attendant costs, because deterring a litigant from accessing court may also have catastrophic consequences for the country. I submit that an election petition is not a personal matter. That's why the person is not at liberty to simply withdraw. He has to convince you, which we are here to do. My lords, Odoki CJ, in the second authority of Dr. Kizabe CJ versus Museveni Yoweri Kaguta, election petition, presidential election petition number 1 of 2006, again, a similar finding was made, and I refer to page 29 and 30 of the judgment of the Chief Justice. In addition, my lords, the other justices on this concurred. Those principles apply to the 3 respondents generally, but with particular reference to the second respondent, the Electoral Commission, my lords. The situation is made even much better and easier for this honorable court. In the case of Professor Arthur Peter Musarika, a similar finding was made, and we have highlighted at page 39 of the bundle of authorities. But when you go further to Raila Odinga, at page 46, this is where there is particular reference to the Electoral Commission, which is the second respondent in our case, in addition to the principles I have already elaborated in the authorities. At page 46, That is paragraph 311 of the decision of the Supreme Court of Kenya. On costs, they write, we're aware that costs generally follow the event, but the present petition has brought for the need for IEBC, that is the Independent Electoral and Boundaries Commission, to adhere strictly to its mandate and not to exhibit the casual attitude it did in the conduct of the impending election. And in defense of this petition, it is heavily public funded, a heavily public funded constitutional organ and a burden to Kenyan taxpayers with litigation costs would be a grave matter which would deem unnecessary in the petition. Let each party bear its costs. It is not that somebody would go away without paying costs. Indeed, the petitioner would pay his costs in this case. The first respondent participant in the election and declared to be the President of the Republic of Uganda. What more would such a person require from a citizen who has challenged him peacefully, democratically, and constitutionally? We submit that it would be unfair to gift such a person with costs from a citizen that has challenged his election. But being a public interest litigation, allows, and with more specific reference to the Electoral Commission, the affidavit in rejoinder by Okasha Sekaja even did raise a more important legal issue that court may find a pleasure in holding that the petitioner should not pay costs for the second respondent. And this is an issue of procurement. The stated is aware that the second respondent in procuring the services of the advocates of the law firms mentioned, due process of procurement was not followed. And we have not received rebuttal to that extent. The PPDA, my lord, requires, that is the public procurement and disposal of public assets, applies with equal force to the second respondent, who never went through that process in procuring the services of those law firms mentioned, which Honorable Stephen Tasholia mentions to have been to have been engaged. The third authority that I had intimated to court, which is going through the sanitization process of court, my lords, with your permission, and which we hope will be availed very shortly, is the decision of the High Court, which I invite you to find applicable in the circumstances, of Attorney General, the Honorable Peter Nyombi, versus Uganda Law, and the Attorney General and the Honorable Peter Nyombi versus Uganda Law Society, a decision of the Honorable Justice Musota. In particular, at page
what court was that?
my lord, thank you very much. It was the High Court. It was a decision of Justice, the Honorable Justice Stephen Musota in the High Court. And that's why. That's why I invited this Honorable Court to adopt it and find it persuasive. Thank you, my lord. So, in particular, he reads, I agree with the submission by Land Council for the respondent. Sorry, my lord.
It's a legal word of phrase. How does the Supreme Court treat decisions of courts in lower abuse or of other jurisdictions?
They are.
My lord, such decisions are said to be persuasive.
The court can find them persuasive.
I invite you to find so. Thank you, my lord.
It is up your time.
Thank you, my lord. And the beauty is that
I want to know what your prayers are.
my prayers to invite this Honorable Court to find pleasure in allowing the petition to be withdrawn and to order that each party bears its costs. I I so pray, my Lord.
Yes, that was the... Just a moment. Let me get back to Mr. Mbele. Mr. Mbele, what have you pleaded with regard to cost in the application? Would you like to go back there?
My Lord, for the costs of the application and the cost of the petition for each party.
In the application. This application you're prosecuting now.
Yes, my Lord.
What was your plea regarding cost?
I pleaded, my Lord, that the costs be provided for. And
Is that the same as each party should bear their cost?
My Lord, provision for costs, as I understand it, and subject to your guidance, is that when you provide for costs, you make your orders. And the orders I'm praying for is that each party bears its costs, both in the petition and in the application. I thank you.
Thank you. Yes,
Thank you very much, my Lord, and the justices of the Supreme Court. For the respondents, we will start with the first respondent.
Each of the respondents will have 20 minutes.
Thank you, my Lord. And we'll start with the first respondent.
First respondent.
Yes.
For some reason, either you're taller than the microphone or it is faulty. No, you have to speak louder because you have a barrier covering your mouth, so you have to fight against.
I will speak louder, my Lord.
That's better.
My Lord Chief Justice, my Lord Justices of the Supreme Court.
Would you like to sit down so that it is, because we're more interested in getting your record?
My Lord, I'll hold this higher.
Oh, fine. Or you pile up books and then...
Yes,
Yeah.
I'll pile them up and then shout.
No, do not shout.
Thank you, my Lord.
You have headache by the time you finish 20 minutes. Proceed.
My Lord, I'm Edwin Karjire for the first respondent. My Lord, we do not oppose the application for withdrawal of the petition. We, however, seek to address court first on the orders that are consequent upon withdrawal, but also, my Lord, we want to use the opportunity to correct some of the falsehoods that have been relied on by the applicant in support of this application. My Lord, I'll first start with the false statements and unfounded beliefs, which are typified by round 3 of the notice of motion, as well as paragraph 19 of the affidavit of support. My Lord, round 3 of the application states that procedural rules governing the presidential election petitions have been applied to disadvantage the petitioner and his petition, in that A talks about the dismissal, the disallowing of the application to amend, and B talks about disallowing the application to file additional affidavits. Paragraph 19 of the affidavit of the applicant states, my lords, that after deeply reflecting upon the foregoing circumstances, I reached the decision that withdrawing the instant petition is the right thing to do, since court is not handling the petition with the independence, impartiality, and equality expected of it. My lords, much of what has been alleged by the petition as partiality, lack of independence of the court, and also as harassment by the respondents is manifest false. And it has very grave consequences, and it cannot go unanswered. However, my lords, ultimately, all this is just a arbitrary point. In our opinion, one ought to simply ask 3 key questions. We need to cut through all this noise and ask 3 key questions. One is, was the petitioner afforded a reasonable opportunity to file a petition challenging the 2021 election? And in answering this, starting point, my lords, is the law. The petitioner was afforded 15 days by the law from the declaration of the results. And this was a 50% increment to the previous electoral cycle of 10 days. In comparable jurisdictions, we have markedly shorter times. Kenya has 7 days, Malawi 7 days, Zambia 7 days, Rwanda 48 hours, and Tanzania you cannot even challenge the results. My Lord, there are only 2 other comparable jurisdictions which have a longer time, which is Ghana and Nigeria, which have 21 days. But in those jurisdictions, you can swear in the winning candidate while the petition is continuing. My Lord, in our opinion, the 15-day period is adequate and is more than is given by other comparable jurisdictions. And this is necessary, my Lord, so that we have certainty in order to prevent anarchy that a prolonged electoral dispute can bring. The next point, my Lord, to answer the question of whether there's a reasonable opportunity to file a petition, is to look at the facts. And the first fact, my Lord, is that the petitioner got 2 extra days beyond his requested time filing this petition. The petitioner wrote to this court seeking the opening of the registry on Saturday, the 30th of January, in order to file his petition. Rule 12.2 of the Presidential Election Petition Rules allows the opening of the registry on weekends by order of the Chief Justice, but this only applies after a petition has been filed, not before. The court instead allowed the petitioner to file his petition on Monday, 1st of February, which was 2 extra days beyond his requested filing time. When the first respondent was required to file its answer, the last day fell on a Saturday, but no such accommodation, my Lord, was given to the first respondent, and none was requested for filing. Instead, the petitioner and his party officials were publicly castigated and ridiculed in court for opening on a Saturday for the first respondent to file its answer. Of course, forgetting that the petitioner got 2 extra days beyond his requested time. My Lord, the court could rightly have insisted when it received the letter on Friday that Friday the 29th was the last day for filing, but it did not. So our court's accommodation, which wasn't extended to the first respondent, has turned out to be a source of attack, ridicule, and baffling. My Lord, the second fact is that the restrictions which were imposed on the petitioner's movement after the election did not impair his ability to file a petition as he continues to allege in this application and in previous applications. My Lords, on 6th of February, the petitioner filed an application for leave to amend his petition. He stated in the application that his phone signals were blocked on the 14th of January and his freedom of movement was restricted from the 16th of January. And that it was only after the lifting of the restrictions on the 25th of January that he was able to gather evidence and to file the petition on the 1st of February. This, my Lord, is not true, as shown by the following. One is that the petitioner's own lawyer, Turiamsima Geoffrey, in his supplementary affidavit, states that he was in phone contact with his client at all times during the restrictions. We have attached the affidavit in reply of Mr. Oscar Chika. Honorable Zake, also in his affidavit, states in paragraph 41 that on 16th February, he received a phone call from the petitioner, summoning him to the petitioner's home in Magere. It is not therefore true that he had no phone contact with the outside world, as he falsely continues to allege. These 2 affidavits were submitted by him, so that from the 14th, there was a communication with both his lawyers and his party officials. Secondly, my Lord, the affidavit in reply, third respondent, in miscellaneous application number 1 of 2021, clearly showed that the averment that the petitioner was only able to meet his lawyer on the 25th of January is false. The affidavit of the third respondent sworn by the Deputy Attorney General, attached a register book that clearly shows that he first met his lawyers at first place. Therefore, my Lord, in answer to the question as to whether the petitioner was afforded a reasonable opportunity to file his petition challenging the 2021 presidential election, the answer is clear, yes. He was in telephone communication with the lawyers and party officials at all material times, and this was ample opportunity for him to coordinate evidence further. He met the lawyers as early as 21st of January and even got 2 extra days beyond the time he said he was ready to file a petition. The second question, my Lord, we need to ask ourselves, in order to cut through the noise, the unprincipled noise, is was the petitioner afforded a reasonable opportunity to present his evidence in support of the petition to this court? And our answer, my Lord, is yes, and it's demonstrated by the following. One, is by the 4th of February, the petitioner had all the old and all the new evidence that he needed to prove his case. And why do we say this? It's because in the affidavit in support of the application to amend the petition, the petitioner stated that with the help of senior officials, he had discovered new evidence that warranted amendment, and that he attempted to file the amendment without leave on 4th of February. Now, paragraphs 10, 12, and 14 of Chaplain's affidavit. Clearly, my Lord, he had evidence on 4th of February, but he did not file on this date. Another opportunity, my Lord, arose on the 9th of February, when this court allowed the petitioner to file all his old and new evidence. And that was during the application for amendment of the petition. The court, in its ruling on the amendment of on the application for amendment, did not find that the amendment was necessary, since most of the grounds which were in the amendment had already been pleaded in the opinion of the court, apart from one new ground which had to do with qualification of the first respondent, which was time barred. My Lord, the court explicitly stated in its written ruling that all that was left was for the petitioner to produce the same evidence for which the amendment was sought. My Lord, this ruling was actually prejudicial to the respondent, because by doing so, court had allowed submission of evidence to support grounds that had not been particularized. They had been pleaded but not particularized. So it should have been the respondent's complaint. But even with this golden opportunity that came on the 9th of February, no such evidence was filed on this date either. My Lords, 2 days later, on the 11th of February, another opportunity presented itself when a pre-hearing conference was held by this court. My Lord, on the 11th of February, the petition applied on adjournment of the pre-hearing conference, and counsel stated on the record that he had 50 affidavits ready for filing that very day, and another 50 for Monday the 15th, and that was substantially from the gist of his case. And the court granted the adjournment and gave the petitioner up to 5 p.m. on 14th of February, Sunday, to file all his evidence, which he undertook. Because no affidavits were submitted on the 11th of February, yet he had them and had undertaken to file them. But instead, 53 affidavits were filed at the last minute of the last hour of the last day, 14th February, and even then with fewer copies than required by court, only 7 were filed. Because this was 10 days after the petitioner had tried to amend upon discovery of new evidence. Court accommodated the fewer copies, notwithstanding that it offended the rules. This further accommodation too has not tempered the false accusations leveled at this court. Clearly, no good deed goes unpunished where the petitioner is concerned. Some of the affidavits that were filed on this day, on the 11th, on the 14th, are dated as far back as 9th of February. My Lord, during the pre-hearing, the court was clear. The timelines were strict, and the registry would not receive late file documents. My Lord, during the pre-hearing, the court was clear. My Lord, Notwithstanding this clear directive and order of court, the petitioner still sought to file extra volumes on the 15th after the expiry of time. The court was also clear when it stated that a party would be very lucky if an application to file an affidavit late was allowed. But on Wednesday 17th, we were here where the petitioner tried his luck, and not with 1 or 2 affidavits, but with 200 for which he sought the leave of court. The effect of this on the calendar, the court has been very clear, because the respondents would need at least 7 days to respond to these allegations. And if this was taken out in court's time, the court would only have 3 days to render a decision. This was clearly an attempt to try the case by ambush, or even worse, to fail the decision of the court. I know the applicant also filed the aforesaid application for leave to file extra evidence based on lies. The petitioner claimed that he had sufficient ground for enlargement, but was premised squarely on a lie of the petitioner and his advocate, counsel Wameli, to the effect that the affidavits were in court on 14th of February. So when your application is based on falsehood, a sufficient cause, what should you reasonably expect as the outcome? The application for leave also stated that his witnesses were prison. However, this was not plausible, my lord, because the names of the detained were not mentioned in the application, and neither was proof of the detention availed. In any event, how can someone be a witness if you haven't interviewed him? How do you know what they have to say? How can security agencies arrest your supposed witnesses when you not file a list of witnesses to identify them? Because there's no unique sign that identifies someone as a Chaguranyi witness simply by looking at them. This was not a credible ground. The other allegation that was raised is that petitioner's offices was under siege. But as shown, he had his evidence by 4th of February. So clearly the witnesses and evidence were not in that office. Lastly, the petitioner claims that he was under the impression that affidavits in support would be filed at any time of the trial. The Lord's Court was very clear during the pre-hearing that timelines were strict and the registry would not receive any late filed documents. His counsel too gave the undertakings on 11th Feb that timelines would be met. So who gave the petitioner the impression that court did not mean what it said? Or did the petitioner think that court orders are merely suggestions where he's involved? In any event, my lord, the allegation that affidavits, the practice for affidavits to be filed at any time is not true. So my lord, on the question as to whether the petitioner was afforded a reasonable opportunity to present his evidence in support of the petition, the clear answer is yes. Timelines were reasonable, and the parties undertook to reach them. All these were reasonable opportunities squandered. The third question, my lord, we need to ask in order to establish whether the unprincipled noise of the hearing is worth our attention is what is the nature of the evidence produced by the petitioner. And in answering in this, here is where we agree with the petitioner that the evidence on record is not sufficient to support the petition. Why? One, because it is constituted by forgeries. The forensic document examiner, Ms. Sylvia Chelangat, in her affidavit, discloses that 10 out of 15 of the petitioner's affidavits that were examined bear forged signatures. The petitioner in his application before the court today does not challenge the findings, but simply states that his witness's privacy is being infringed on. Firstly, these cannot be your witnesses if you haven't forged their signatures. Secondly, the petitioner attached the national IDs to the affidavits that were produced to this court, so the issue of privacy does not arise. It's the one who infringed on the privacy by submitting their IDs. The petitioner, it appears, was given the impression that he has the right to present forged evidence, and it is wrong for him to be caught. Because his only complaint is that he was caught. This is impunity, my lords. My lords, the evidence also includes admission of offences. The petitioner in his affidavit in support of the petition takes us on a ride around the country together with about 100 of what he calls his personal journalists, campaigners, musclemen, sound engineers, etc. He holds press conferences with foreign media going on the highway, and he has people riding on the roof of his vehicles as he arrives at some venues sometimes between 1 and 2 a.m. Because all these are serious violations of public health and road safety laws. Because the evidence also includes immaterial witnesses. Out of the 53 witnesses who were submitted to this court, 27 are constituency and district supervisors. The supervisor is not a candidate's agent, he's not at a polling station. He has no role to play in the electoral process where it is happening at the polling station. And even has some of the supervisors coming from Busia, but they're supervising the election from Marachi. All they can say regarding election day is hearsay. So the only ground there for my lords on which we agree with the petition is that he has no chance of succeeding in this petition with the type of evidence he has adduced. And since the 53 affidavits are a sizable representative portion of his evidence adduced to overturn the election, is it reasonable to assume that the rest of the evidence that was left out bears no forgeries, no falsehoods, no admissions of offences, and no irrelevant matter? Because I think such an assumption would be unrealistic. My lords, it should therefore come as no surprise that the first respondent does not oppose the withdrawal because the petitioner was playing a treacherous game which has no rules and which we are therefore happy to leave. He files when he wants, amends without leave, tells lies on oath, submits affidavits with forged signatures, and takes pride in subjecting the arbiter of this dispute, yourselves, my lords, to insult and public ridicule in the media. My Lord Chief Justice went to great lengths on 2 occasions to remind the parties about the seriousness of this undertaking. But with total lack of decorum and contempt, the petitioner held a press conference to announce the decision to withdraw the petition, and not another media attack on this court. Counsel Wameli was still on MTV on the 23rd of February 2021, maligning this very court. Details and the affidavit of Mr. Chihika in reply. All this scandalous conduct, my lords, is akin to verbal wars that we have only seen between rival singers. Yet this is a serious undertaking. My lords, 3 members of this bench have been publicly attacked because the petitioner states that he's not comfortable with them handling this matter. Then why not file a recusal? File for recusal format. Why address this in the press only? Why not submit your allegedly overwhelming evidence on time to the court? Since the 6 members who are not averse to, are the obvious majority. Clearly, either the intention of the petitioner was not to advance an inquiry into his petition, or the petitioner's mathematics is as bad as his manners.
Are you concluding?
Yes, my lord.
Conclude.
Yes, my lord.
In the presentation, it is apparent that there are no grounds for leave. We have no such thing. And yet we have gone ahead to concede. We have gone ahead to concede the application for leave.
My lord, thank you.
What are your reasons for your concession?
Thank you, my lord. We concede that the evidence on record is not sufficient to support the petition, and this is contained in the affidavit of Lukash and Sekaja, paragraph 4. That is the only ground we concede. The rest of the grounds, my lord, we do not concede. On that alone, we were in a position to concede to court granting leave for the petition to be withdrawn. My lord, I will also seek to address the issue that was raised in the affidavit of Oscar Chihika, of the petitioner saying he's going to the public court. This is a very serious statement, because we all know that power belongs to the people, Article 1 of the Constitution, 1:1, but that very article states that it shall be exercised in accordance with the Constitution. Article 1:3, all state power emanates from the people, who shall be governed through their will and consent. Article 1:4, such consent is expressed through regular, free and fair elections. And if I may add, not through mob action. The people express their will and consent, my lords, exercise their sovereignty on 14th January 2021. And the second respondent announced the people's verdict on 16th of January, returning first respondent as president. So what then, my lord, is the public court? This is the public court. Article 2126.
Council, each of your 20 minutes, I'm giving you 5 like I gave your very friend.
I appreciate that, my
Make
lord.
sure you conclude within the next 5 minutes.
My lord, I have my colleagues to borrow time. I don't know if court can allow me to borrow some time from them.
From which colleague?
Second respondent.
Come again?
From the second respondent, my lord.
How much time?
5 minutes, so 10 minutes I should be there. My lords, 5 minutes plus my colleagues 5 minutes.
Now, my lords, you can see how they work together.
Well, they're all respondents. You brought them together, Council.
My lord, we are sued together. If you sued us separately, my lords,
So this is what we'll do. If you take the whole of their minutes, then we'll go to the third respondent. So whatever minutes you take from them, they speak less by that time.
okay, my lords, I'll move through very quickly. My lords,
So you borrowed 5?
and my lord has graciously given me 5.
Yeah, no, because we interrupted you. So to be fair, I gave you 5.
Yes,
Now, if you take 5 from him, when we reach him, we'll speak for 15 minutes.
yes, yes,
Or
my lord.
not more than 15 minutes.
Yes, thank you, my lord. This is the public court because Article 126, 1 of the Constitution states that judicial powers derived from the people and shall be exercised by the courts established under the Constitution in the name of the people. An attempt to talk of any other court which overthrows the will of the people. My lord, on 11th February, the court warned the parties against disparaging and bad-singing remarks. But as the affidavit of Chika shows that this has continued and needs to be curbed, my lord, the petitioner quickly forgets that he owes his political career to the court decision in Setenda Several versus Applicant that enabled him to participate in the by-election in 2017. He also forgets that he's currently on bail in 2 matters before Kulu High Court and Igaga Chief Magistrates Court. When his movements were restricted by the state, it was the High Court that he ran to. So it gives no reason and understanding that this is the same person viciously attacking. And of course, the petitioner is undoubtedly modest exposure to the law, generally, structured life outside music. But then what is the excuse of his attitude?
I object, my lords, and I think I have been patient with my colleague, my learned friend, Mr. Karugire, in terms of the language he uses against my client. Civility and the conventional practice would require that an advocate at the bar conducts himself in a befitting manner. If I started talking about his client outside politics or outside this court, I am sure there will be chaos in this court. May I invite court to restrain him, making disparaging references to my client.
Let's address ourselves to the evidence that have been adduced in this application, either by the applicant or the respondents.
Thank you, my lord. I'm most
But
obliged.
and second, for anything that has been said outside of what your presentation was, we have a whole 10 minutes of rejoinder. So you have an opportunity.
That's correct, my lord. I am only objecting to what goes on record, which is an insult to my client. I also have enough about his client.
I have ruled on that.
I'm much obliged, my lord. My lord, the law anticipates that matters of this nature will happen, and that's why Article 128(1) protects this court from interference by third parties It also punishes consent. Contempt of court is also punished under Section 107D of Penal Code Act. And this is in addition to the inherent powers of this court to punish people who act in contempt. This court should not turn a blind eye to this travesty. My lords, the sum of this all leads us to the conclusion that the petitioner has no evidence to support his petition, and the highest court of our land has been used as part of a political theatre, but not to resolve a legal grievance as the law envisages. We pray that the court is pleased to grant the leave requested by the petitioner. Do not oppose the grant of the leave, but we pray that it be done on the following terms. One is a declaration that the first respondent was conclusively elected as President of the Republic of Uganda. This is a consequence of withdrawal of the petition under Section 59(4) of the Presidential Elections Act, where the petition is filed within the time prescribed under subsection 2. Where having been filed is withdrawn, the person who filed it, the candidate declared elected shall conclusively be taken to have been duly elected as President. Second, we pray, my lords, that the first respondent be awarded the cost of the petition, and Section 64(1) of the Presidential Elections Act, Rule 27, the rules, the petition is withdrawn. The petitioner shall be liable to pay the costs of the respondent. This is the other consequence of withdrawal. We are aware, my lords, that in previous petitions the court has not granted costs. However, we submit that in those cases there was no withdrawal. So the above, the precedents which were stated by a learned friend for the petitioner are distinguishable. We submit that the specific provisions of the rules in respect of withdrawal creates a liability on the petitioner to pay the respondent's costs. Also, the conduct of the petitioner in this matter makes this a fitting case to award costs. My lord, Section 27 of the CPA, which gives courts discretion, is stated to be subject to the law. And the law here is Section 61(4) of the Presidential Elections Act and Rule 27 of the rules. Therefore, these two take precedence. Secondly, the cases discuss the petition, cases submitted by my learned friend discuss a petition that has been handled to its conclusion. And in that case, Rule 23(1) would apply, where court has the discretion to grant costs. That's Rule 23(1) of the Presidential Election Petition Rules. However, on withdrawal, Rule 27 applies, and it is specific. And even if discretion is granted by the statute,
Conclude your prayers.
Thank
You have just 1 minute to finish your 10 minutes.
you, my lord. Even if discretion was granted by the statute, my lord, with regard to costs, the petitioner fails the tests laid down to the own authority. It has to be a genuine grievance that was brought to the court, not one of this nature. For these reasons, my lord, we pray for costs in the matter and for a certificate for additional counsel on record, given the importance of the matter, the difficulty, volume of work entailed. We so pray, my lord.
Yes, Counsel. You have 15 minutes within which to make your submissions.
Much obliged, my lord. My Lord Chief Justice, my lords, Justices of the Supreme Court, for the record, I am Ellison Karahanga for the second respondent. My Lord, I will begin by associating myself with the very able and erudite submissions of my learned friend, Mr. Edwin Karujiri. My Lord, it is axiomatic that this court cannot force a petitioner to proceed upon a petition that he himself agrees is unmeritorious. So to that extent, my Lord, we do not oppose this application. Further, my Lord, We agree with the petitioner and associate ourselves with him when he says that no agreement or corrupt bargain has been entered into between the parties. So also to that extent, we do not oppose. We associate ourselves with Mr. Karujire insofar as he has listed the conduct of the petitioner. My Lord, we also wish, my Lord, to very precisely state that this Honorable Court's refusal of 2 applications does not show or constitute what Honorable Chakulani defines in his affidavit as impartiality and lack of independence. As officers of court, we feel enjoined to state that the averment of the petitioner in that regard is not correct. This court is under no obligation to allow incompetent, incomplete applications. So to the extent that the court is being accused of partiality in this very application, when in fact no such a...
Councillor Karwanga, I don't remember the court saying they disallowed incompetent, incomplete applications. I don't know where that one is coming from.
Much obliged, my Lord. Maybe if I rephrase, this court is under no obligation to allow unmeritorious applications or applications that lacked merit or that contained falsehoods. My Lord, the petitioner has elected to use a lot of his energy to argue that each party should bear its own costs. But his application makes no such prayer. He does not apply to this court to exempt him from the consequences of Section 61. In fact, he has only 2 prayers in his application. The first is that he be granted leave to wholly withdraw. The second is for costs for the application. There is no order or there is no request to this court that this court should not...
No, even that one is not correct. He does not ask for cost. He asks that cost be provided for, and remember, I reminded him, I went back to him for that purpose. And he says his prayer in the submission falls within provision of cost. That's what he told me a few minutes ago.
Yes.
He didn't ask for cost.
Yes. No, my Lord, I'm saying...
He pleaded with court to make provision for cost. And then when I asked him, he said, the prayer now that each party bears, their cost falls within provision of cost which I pleaded with application.
Much obliged. But my Lord, that prayer is about this application. There is nothing about the petition in that prayer. Section 61(4), because his prayer says costs of this application be provided for. Section 61(4) says that if a petition is withdrawn, it shall be liable to pay costs. So he has not prayed in his application which provides that costs shall follow the event, including previous presidential election petitions. My Lord, those matters were not dealing with Section 61(4). Secondly, my Lord, he has brought the authority of Raila Odinga, where the court said that because of the way the IEBC in Kenya had conducted the election, that each party should bear its own costs. It's worth noting the distinction is that in that case, the Electoral Commission of Kenya had been found not to have arranged the election in compliance with the law, and the court annulled that election. So it's a distinction. He has also, relying on the affidavit of Sekaja Ukasha, talked about procurement and said that there was no reply to this averment. My Lord, was an affidavit in rejoinder. There was no right of reply to that averment. It was also an affidavit in rejoinder that brought new matters. Mr. Ukasha had no right to bring new matters in a rejoinder. Thirdly, it was an affidavit by counsel on a contentious matter. Mr. Ukasha has no right to respond to a contentious matter. And fourthly, it is an affidavit about matters that are purely not within the knowledge of Mr. Ukasha, since he is not a procurement officer.
Was Mr. Ukasha's affidavit in agenda, or was the second affidavit in support of the judicial investigation?
The one he's referred to was the one in rejoinder. Paragraph 4, he relied on paragraph 4 of the rejoinder. The paragraph 2 of the rejoinder, which was deposed on the 27th of February, after the application had been filed. To the extent that it is not a matter that was within his knowledge, it is a contentious matter, it is a new matter in rejoinder, that paragraph, my Lord, we pray should be struck out. In any event, the issue of instruction fees is not for your lordships, it's for the taxing master, for any costs that would be applied. So, my lords, we associate ourselves with the submissions which have already been raised by the first respondent, and we pray, my lords, that this court be pleased to allow the application to withdraw, and that the requirements of section 61, because what the prayer is that the court does not apply section 61, because section 61 subsection 4 is very clear. The petitioner shall be liable. The language that's used is mandatory. So we pray that first of all, no reason has been advanced as to why, and secondly, that this court be pleased to grant the costs of this application. My Lord, we so pray. The cost of the petition, not of this application, my Lord. The cost of the petition.
Thank you. You spared us 5 minutes to congratulate you for that. Learned Attorney General, can we hear from you, for the third respondent?
Thank you very much.
Thank you. You've spared us 5 minutes. We congratulate you for that. Learned Attorney General, can we hear from you for the third respondent?
Thank you very much, my Lord, the Honorable Chief Justice. Justice of the Supreme Court. The third respondent appears before you in this matter by way of an affidavit in reply that has been deposed to by the Honorable Jackson Kafuzi on the 26 presidential election petitions, as has already been discussed here, is provided for under section 61(1) of the Presidential Elections Act, number 16 of 2005, which states as follows: that an election petition shall not be withdrawn, except with leave of the court, and after such notice has been given as the court may direct. My lords, the applicant has indeed sought leave of this court to withdraw this petition. Such notice has been given as the court may direct. My lords, the applicant has indeed sought leave of this court to withdraw this petition. And there has been no agreement of any kind with the applicant to withdraw the same. This is illustrated in paragraph 25 of Honorable Jackson Pafuzi's affidavit in reply to the application. My lords, the third respondent has no objection to the application to withdraw, except counsel for the first and second respondent, our only concern is that the grounds, or some of the grounds that are being relied upon, our only concern is grounds that are falsehood, falsehoods, and that is why we feel duty-bound to point them out. For example, we have no objection to the grounds being relied on in paragraphs 1 to 5 of the application. The applicant, my lords, in his paragraphs 2, 4, and 5 of his affidavit in support, avers that the matters concerning his house arrest influenced his decision to withdraw the petition. Further, that he was not able to communicate with the outside world and could not instruct his lawyers after his release. As illustrated in our affidavit in reply at paragraph 4, his own advocate, Turiamusi Geoffrey, and Mr. Zaki Francis, his close associate, were communicating with him. So all I wanted to point out here was that that particular vermin is not true. Further, my lords, it is our submission that much as it's the applicant's entitlement to withdraw his petition, he should not do it the basis of force to the financing to the justice asking outcome agreement, and then you seem to be opposing. All we are opposing, my lords, is where the reasons given contain falsehoods, basically. In grounds 3 and 5 of the application were already raised. They were then submitted upon by all the parties, right here in this court, and a decision was arrived at by the Supreme Court of Uganda. So those were matters that were tried, and a decision was arrived at.
Can I ask one question?
Yes.
What would the position of the law be? What do you consider as the position of the law? Where a petitioner seeks leave of court to withdraw a presidential election petition, the respondents are not opposing, as is the case now. Can the court be inclined not to grant nonetheless?
I've thought about that, surprisingly, my lord, because it would leave the whole court in a paradox. Because if you have a person who is not ready to pursue his petition on the grounds that he himself has decided that he is incapable of meeting the standards for the potential success, then he will be in a quagmire. He cannot continue because he knows he's going nowhere, and by his own admission, and he's the one in charge of preparing his case, has discovered that his case is not strong enough. I wonder what would happen if the court decided that he continues. Right?
In effect, there will be no alternative except if another presidential candidate takes office.
Precisely. That would be the one opening. There was such a threat, but I think it suffered a stillbirth. I don't know about it.
We know nothing about that.
Thank you, my lords. So, my lords, it is our submission that much as it's the applicant's entitlement to withdraw his petition, he should do it against well-known legal principles. That's what I said, which is very clear in the Presidential Elections Act. So my view is that regardless of the...
In effect, you adopt Council Carolina's submission.
By and large. By and large, yes. By and large, I do. My lords, again, at the expense of repetition, I already said that the matters in his application 3, 4, and 5 were already adjudicated upon before this very court. And I'm saying that the right to withdraw does not allow you to reopen already concluded matters, and more so those that have been adjudicated upon, in this case, by the same court. But like you say, I associate myself with the first respondent's submissions. However, the ground 2, for example, where the applicant alleged that the Uganda police and national identification of registration of persons authority were being used by the respondents to investigate and infringe on the privacy of the petitioner's witnesses. The third respondent's response to this ground is contained in paragraph 17, 18, and 19, my lords, of Honorable Jackson Kafuzi's affidavit. And by and large, we are saying, well, if they are forgeries and they themselves are attached to national IDs, the law enforcement authorities are not about to check. Again, learned counsel for the first respondent submitted on that. And this was premised on reasonable suspicion that the signatures appended to the affidavits were forgeries. And the forensic document examiner actually found this to be so. So we just thought that that should be brought up. Then one that perturbed me, and I already spoke about this earlier on, my lords, the applicant in paragraphs 14 to 19 of his affidavit in support for withdrawal makes these affirmations that the court, in his opinion, was handling the petition without exhibiting independence, partiality, and giving all parties equal rights before it. It is the third respondent submission that, of course, the applicant was given an opportunity to be heard, and that the decisions of the court were founded in law. Therefore, to allege that he has been denied substantive justice on the sole grounds, it would appear now, that the rulings were not in his favor. That's not the same as saying that the court acted with independence or without independence, with partiality, and didn't give all the parties equal rights. But this, we traversed it a long time ago, my lords. I think I would hope that this court will make the appropriate findings on that. These affirmations we find unfortunate. I really don't want to belabor this because we went through this. We find them very unfortunate, without merit, and now to come out at this stage of the presidential election petition, at the point when you are withdrawing, we find that that was not in good taste. We hope that the applicant is advised that parties come to courts of their own free will and do so in their quest for justice and finality of matters. But once they do so, once you come to the court, like I said, we're going to traverse this, you should abide the rules of the court and must desist from the kind of gimmicks that and brinkmanship that we have been made to endure. But again, like I said, we traversed this before. You come to court, then you must abide court. This is the first time we have a candidate for the highest office of the land coming to court to seek justice and then turning around to cast aspersions on the same court. That's where you have got to seek justice, but that's where you're casting aspersions. I think this type of conduct should be castigated. Never mind, my lords, that we are reminded that the same applicant has severally sought court's intervention and successfully. For your information, my lords, just for you to take judicial notice with your permission, I would like to take judicial notice of 2 cases in which the petitioner applicant, in particular, has used the courts to seek redress in his favor. In the case of Basil Diffasi and 3 others, versus the National Unity Platform and 9 others. The National Unity Platform, of course, is the political label for the applicant. Miscellaneous clause number 226 of 2020. His Lordship Justice Musa Sekana, in his judgment on the 21st of October 2020, where court validated the nomination of the applicant, petitioner, as the flag bearer of the National Unity but for the position of presidential candidate. I think the allegation there was a group trying to steal the party, and the petitioner came to the court, and the court said no, the other group was wrong, and it said you were the rightful owner. I think that's one clear example of a successful petition to the court. Also, in another one, Senator Robert Chagulanyi versus Attorney General and 2 others, this is miscellaneous clause number 16 of 2021, His Lordship Justice Michael Eluku, this was on the 23rd of January 2021, found that the confinement of the applicant in his home was unlawful and ordered the restriction to be immediately lifted. It's another example where you've gone to the court and the court has done you justice. That's why we find it rather ironical.
Complaint by the petitioner is treatment and the Supreme Court in this particular petition. So he's not complaining about the other courts, the other incidents where he was treated very well by the courts.
Oh.
I think that's what I read.
Well, I'm not sure about that, my lord, but the court structure, as we all know, starts from down there and ends at the Supreme Court. I would find it ironical for one to find one segment of the court to be correct and the other one not to be. I will leave that to your own interpretation, my lords. So we maintain our position. We do not object to the withdrawal of the petition. We agree with the applicant. This is a good thing. The Honorable Segona, we agree with you that in the 4th ground, that in your 4th ground, that in as much as you concede to not having filed relevant affidavits and evidence in support of the petition, in our opinion, that evidence adduced was insufficient to sustain a successful petition. We agree with you on that. We submit.
Let me ask this.
Yes,
any of those evidence contained in the 53 affidavits, didn't any of them pertain to what amounts to electoral offense? In which case you don't need 2 of them, you need just one.
in that case,
You would need just one piece of evidence to prove and have a presidential election overturned.
yes, you only need one, my lord, and that is why this court allowed him to file extract affidavits, or if not, that the affidavits before it were sufficient. What they needed to do was to test the evidence, and had this petition proceeded, that's what we would have proceeded to do, to make our case about why we thought there would have been no electoral offense committed. So, my lords, we submit that this withdrawal should be sanctioned, and also that the first respondent, now I'm talking in the context of section 59(4), should be declared as the duly elected president of the Republic of Uganda, in accordance with section 4 of the Presidential Elections Act, that provides that where no petition is filed within the time prescribed under subsection 2, or where a petition having been filed is withdrawn by the person who filed it, as is the current case, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected as president. My lords, we further undertake that in accordance with Regulation 23 of the Presidential Election Petitions Rules, no agreement or terms of any kind has or have been made, nor any undertaking in relation to this petition between the third respondent and the applicant. Now, lastly, my lords, on behalf of the third respondent, and in line with section 61(4) of the Presidential Elections Act and Rule 27 of the Presidential Election Petitions Rules regarding costs. Now, counsel for the first and second respondents, my lords, have submitted quite comprehensively on this specific prayer. I find no fault with their submissions on that. I associate myself with them, except that, of course, this particular item gave me quite some thought, especially in my capacity as the AG, because on the one hand, there's the desire to have the petitioner and or his lawyers to be condemned in court, not necessarily specifically because of the withdrawal, but also because, in my opinion, of their general conduct. Of course, under the law, there is provision for that, but just the general conduct as well. The false averments, the media theatrics, the denigration of our temple of justice, this court, the double standards I just referred to, they start to be corrected by Justice Araj. Because I was saying that one morning you were in a courtroom seeking to salvage your party from some people you describe as unscrupulous. On another day, you are seeking your property from the police.
On the word unscrupulous, I strongly object.
No, but I'm talking about, when this was in the courtroom, I'm talking about the people from whom I said he was seeking to salvage his party from some, and he was saying some unscrupulous people who wanted to take the party. I'm not saying the petitioner is unscrupulous. The petitioner was saying that there were some unscrupulous
My lords, to the extent that certain allusions are made with reference to my clients, and trying to create a huge distance between a petitioner who is in this court and the court, that's the basis of my objection.
No, Councillor, I think you're not following what the learned attorney general is saying. You see, it's been your case. You've settled, you've laid down grounds for seeking withdrawal, and respondents responded. Among the things they brought forward is that, I'm paraphrasing, the petitioner used both the court forum and outside the court forum to conduct his petition. That's really what they are saying. And if I understand the respondents, they say, because of all this is not one of those cases where the parties should bear their own cost. The petitioners will be compelled to bear cost. Whether I agree with them or not, I don't know. I will have to consider all this. But, and if you look at the affidavits and what it is some of the things which have been said. I don't know what you think about those. But as I said, you have your 10 minutes to respond.
Yes.
And set the record right. If you think whatever has been said is not true, it will go down the records.
Okay. Okay. Most obliged, my lord. So I was just saying in conclusion, I thought that point I made was crystal clear. But
you can conclude.
In conclusion, yes, my lord. This is what played out in itself in my mind for me to think that if there was a time when opponents should be slammed with costs, I was thinking this was such a time. The thing is that
Yes, my lord. Honestly, I don't know what my view would be about cost. Are there remedies for utterances and becoming utterances? If anyone, forget the petition, if anyone who's come to court has made either in court, this court dealt with a situation where somebody came to court and made unthinkable utterances, something we've never seen in this country before. If somebody makes utterances which offend the courts, either in court or outside, then there are different remedy provided for under the law is cost the appropriate response.
Thank you, my lord. And it was actually part of my conclusions that despite all that, I juxtapose this, first of all, against my position as the head of the bar, then the issue of the national importance of this matter that we are in agreement with. We are all in agreement about the national importance of this matter to our citizens. And also, my lord, I consider the advice of this court earlier that my office considers setting up a forum for the interaction of lawyers, especially senior ones, to discuss our general conduct. So I juxtapose this and the need to temper my initial instincts, the one we were just talking about now, to demand for costs. And then I came to the conclusion, my lords, and my lord, this is precisely what you are saying, that I leave this matter to this court. this capable and honorable court to decide on how best, in these circumstances, how best to bring the petitioner to the legal line. I agree with you that this court must find some way to decide on how best, in these particular circumstances, to bring the petitioner to
We would have loved
yes.
to see the Attorney General not sitting on the fence. Come out and say, despite all this, please do not await cost. Because of all this, we think this is a situation where what should have got cost. Whether we'll agree with you or not, but I think we will respect. Like all these submissions you make, we respect them. But whether they persuade us or not, it's a different matter. That's what I thought. I'm not saying we should change, but that's what I thought.
Yes, yes. I would like to maintain that, because you see, my lords, like I said, as far as I'm concerned, this particular case, with its circumstances, is the right type of case for which costs should be awarded to the respondents. I was just expressing to the court my dilemma in the context of what I've already said. Citizenship, and saying that I will therefore leave it to this honorable court, seeing that you have also been, you have also seen all the circumstances of this case, to come up with some manner of sanction to allow petitioners to know that once you come to the courtrooms, you must toe the legal line. Therefore, my Lord Chief Justice and the Justices of the Supreme Court, we pray that the application is allowed, the petition is withdrawn,
Thank you. Council Meda Lubega, you have 10 minutes within which, and please address us on new matters that were raised.
Thank you, my Lord. Like my land friend, Mr. Edwin Karujire, having adjusted my height, permit me to put the microphone up because it seems to be shorter than me. My Lords, with respect to the submissions made by counsel for the first respondent, first, I am glad that the application to withdraw is not opposed except for the reasons. On that alone, I invite your lordships to find pleasure in allowing the application. Number two, with respect to the alleged falsehoods, as well as the so many reasons given by counsel for the first respondent to disadvantage or disable the prayers that we have made, I have the following to say. One, it is within the right of a petitioner stroke applicant to express himself to court on his feelings. One thing I do not and will never condone as a lawyer is attacking institutions that guarantee the safety and tranquility of the country. I have stated at the bar before, and I continue to do so, that whenever given an opportunity, I shall provide my professional voice, whether to this particular client or any other person. But permit me also to submit, as I've submitted before, that the allegations against the applicant are so grave in nature, to the extent that they are touching the relationship of a litigant and this court, a forum he chose to come to. Whoever is making these allegations ought to have done more. When you make reference to a press conference, there is documentary evidence that you can be able to procure. the same respondents who are able to go get a one chelangat from the police, go to NIRA, which is a Department of State, and bring it to say that the signatures presented by the applicant are forgeries, even without producing the people who signed or are alleged to have made those signatures and supplied their declaration, their national IDs. It is so disturbing that such a person cannot procure a recording from a TV station which he claims to have witnessed, and therefore simply comes to soil the name of an applicant in a bid to recruit sympathy from this honorable court. I am fortified that this court has emphasized before that it's not going to be guided by rumors, but rather evidence presented here. My lords, yes, the applicant stroke petitioner.
Councillor Bega.
Yes, my lord.
Thank you for that part of submission. I agree with you. But can I also ask that if such evidence were used in the manner you're saying, and they were proven, they can lead to very serious legal consequences. Fortunately, this is not a matter before us now. I'm only saying because you raised it. For us, we're determining the matter of withdrawal, and we're not dealing with the other matters. They have only raised it to deny the grounds you've given for withdrawal. But it's not a matter for trial within us, before us. But you appreciate that if such evidence were brought before any court, as they allege and proven, they lead to very serious consequences. As a lawyer, you are aware of that.
I have two answers to that, my lord, with your permission.
Can I supplement? There is Oscar Kihika's affidavit, paragraph 30 and 31, which talks about the same thing. And you have not replied to it.
My lord, I thank you again. I have previously, in a similar allegation, made submissions with respect to Mr. Oscar Kihika. And that's why I said, you have no reason to believe this. Why? Because there is a way of presenting conclusive evidence to demonstrate that actually the applicant is as errant as he's being portrayed. My lord, with respect to the question from my lord CJ, the serious consequences, and that the matter is not for this honorable court for trial, but to consider whether to grant or not to exercise your discretion. First, I reiterate the first answer of the veracity of this, which is left hanging without an attachment. But the consequences, yes. As a lawyer, I know. As a lawyer, I know. And I submit that it is the duty of us all to give due respect and treat this honorable court, not only this court, but any court or institutions of state, with decorum. As to whether this should be used in the, or applied or looked at in the exercise of the discretion, that's why I'm submitting no. Why? Because it is left hanging. You have no reason to believe this affidavit of Mr. Oscar Kihika that the petitioner stroke applicant is in the conduct of disparaging and disrespecting court. If anything, the evidence supplied by the Attorney General, which I agree with, my client is a regular user of the courts of law in this country whenever his rights have been transgressed upon. That is a demonstration that he believes in the rule of law and not jungle law as he's being presented. I mean, there is evidence on record.
You know what the learned Attorney General said, I think the other person said, that your client is only happy with court if the court rules in his favor. The moment the court rules against him, then the courts and the other words I cannot repeat them. You know, like, that's really what they're saying.
That's what he said, but I'm giving the proper context My Lord, and the proper context in our humble submission is that the applicant is an ardent believer in the rule of law. That's why, whenever brutalized, whenever transgressed upon, he runs to the same court. He's not running to anyone else. What the effect of the submission from the respondent, from the bar?
But when the court rules against him, then he goes to the People's Court. That is the final court now, above the Supreme Court. That's really what it means.
In my Lord, in the honest belief that you have not believed that rumor, my Lord. I know.
Councillor Bega, I want you now to address us on other things. But let me say this. As a Catholic, people pray a lot of things. For me, Jesus said, we say the Lord's Prayer. I say it twice every day.
Yes, my Lord.
And the one which I remember, it says, even God should not lead us into temptation. I think do not lead the Attorney General, who has said he wants to organize a meeting, which is a very good thing. Don't lead them into temptation. Because for me, I would want this matter to remain where
my Lord, I treat...
And we do our things.
With immense respect, my Lord, to the Attorney General.
Don't emphasize that area, that bring proof.
No, I think...
could be brought, I don't know, unless they are lying.
My Lord,
that's why I was helping you.
May I pray?
Take that route. Let us conclude this matter. Whatever has happened, let me repeat this. Then you continue. As the judiciary of Uganda, which I head, we were never influenced by people who praise us or people who abuse us. You can abuse the Chief Justice, you can abuse the justices of the Supreme Court or the entire judiciary. But when you come before us and you're on the side of the law, we will protect you, the insult you have on us notwithstanding.
My Lord, that gives me comfort that actually you're not aware of those insults because they do not exist. And if they existed, you would have evidence before your lordships.
I think if I may advise Council, why don't we restrict ourselves to the matter before us and avoid extraneous matters?
My Lord, that's my prayer.
Okay.
And that's why I said that the matters placed here are extraneous to the extent that somebody simply comes to say, this man said he's going to the People's Court. I agree with the counsel for the first respondent that this is the People's Court because it is established in accordance with the Constitution to exercise jurisdiction in accordance with the aspirations of the people of Uganda. As to whether, my lords, that is the perception of either the petitioner, the respondent, or other people outside, is not a matter for this forum. Like I did make an undertaking, anything that ridicules the independence and respect of this court, I stand with court.
Proceed.
Thank you, my lord. With respect to cost,
on that. Yeah.
Thank you, my lords. I think something again prejudicial has been said about the petitioner and his advocates. Let me repeat. As advocates, we have done our work in accordance with our professional training and orientation. My lords, a lot has been said in the background. May I invite court to look at that as a background, notwithstanding interpretation on the part of the parties, but the essential elements to satisfy you in exercising your discretion have been satisfied and placed before your lordships, that there is good cause to allow the withdrawal of this petition. I think a lot has been said about costs.
Conclude in 5 minutes.
With respect to costs and the prayers. First, there is no admission of offenses on the part of the applicant anywhere. The alleged forgeries are a concoction by a person who is being strangled before this court and trying to look for evidence to extricate himself. I believe it was within the right of the respondents to extricate themselves. But to the extent that they refer to the signatures as forgeries without being bringing conclusive evidence is also very, very unfortunate. My lords, on the prayer by the respondents that you be pleased to therefore declare in accordance with Section 59 of the Presidential Elections Act that the first respondent was duly elected. The guiding law is subsection 4 of Section 59. 1, it reads, where no petition is filed within the time prescribed under subsection 2, or where the petition having been filed is withdrawn by the person who filed it, or is responded, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected. You do not need to make a declaration. It is not within your power. It will be up to the person was already declared by the Electoral Commission.
What does the law say? The law cited by Counsel for the
there are two provisions, and I want to read both of them.
Please do.
5, after due inquiry under subsection 3, the Supreme Court may dismiss the petition, declare which candidate was validly elected, or annul the election. Now, your power to declare comes into play under subsection 5. After you have had due inquiry into the petition. The process in subsection 4 is purely a political process. It is up to the respondents to say, since the petition has been withdrawn, therefore this man was properly elected. For you to order or to declare that the first respondent was duly elected, it can only come under 5 after you have inquired into the petition, which for now, if you permit the withdrawal, you have not done. My lords, finally, on the issue of costs, I reiterate my earlier prayers, but let me conclude with this particular extract from the decision of Justice Sekoko, JSC. In our bundle...
Do that in 2 minutes.
Thank you, my lord. In our bundle, pages 17 and 18, it is express. My lord, this is election petition number 1 of 2001. He says, even if, and quoting the Indian authority of Charan Lal Sao and others verses Singh 1985 LRC, page 31, that even if the election petition was frivolous, court should exercise its discretion not to award costs because of the public importance of an election petition.
Does that cover even a vexatious one?
It does.
What your learned friends
Yes.
are saying in their response, I'm not saying I agree with them, but what they're saying is that the petitioner was both vexatious, and the petition was both vexatious and frivolous. That's really what they're saying.
My lord, that will take us into the definition of both phrases, vexatious and frivolous. One which does not disclose on the face of it reason for inquiry. If that was the kind of petition we presented, it would even have been one either rejected by the registry or struck out by way of a preliminary objection.
No, that would be on cause of action. You can have a cause of action, but you can still be very vexatious and frivolous.
Yes, my lord. In this case, we submit it was not, to the extent that it demonstrated...
No, what I wanted to know,
yes.
I have not read the authority.
Yes.
It would cover both situations.
It does. It does. Even champ to us causes, my lord, it would be covered. My Lord, the second respondent has submitted that Ukasha Sekaja does not have.
You remember you had 2 minutes only.
I'm now using the last one, my Lord.
Yes, yes.
Does not have knowledge of the procurement issues. The first thing is, what does the law require? The law requires a procurement process which is public, including an advert, for all lawyers who may wish to supply. It is no record that it was done. My Lord, the authority I referred to, which I invited you to adopt and find persuasive, of Justice Musota, involved the same law firm of Kampala Associated Advocates, of procuring legal services. There was an opportunity. It is not true that they could not respond because this came by way of rejoinder. The practice of court is that there is even a such joinder. There is even an affidavit in rebuttal. There is even a provision for somebody to apply for leave to respond to a particular averment. It is also not true that this is so contentious. No. Every lawyer knows the procurement processes and laws in the country. And I want to assume lawyers that really went through law school. And Ukasha says, I know that this process was not followed. It is illegal. It is irregular. It involves the same.
Okay, I'm trying to understand. So your point is, even if this court were inclined to award cost, then the council, the provisions for instruction fee and the other costs which are attendant to council's participation and so on should be excluded.
They would not be entitled to a coin.
But that does not mean the second respondent, is it second? Yes.
First, the first and second.
Or it doesn't mean they will not be entitled to cost.
No, it doesn't apply. In my submission, I said specifically with respect to the second respondent.
Yeah, this is what I'm saying.
Yes.
Would it mean the second respondent would not be entitled to cost? Or if it is being taxed, the lawyers who have represented it here will not be entitled to cost?
My Lord, that's why I submitted that to the extent that the procurement was illegal. Now, the second respondent, which costs would he present? Would it present? And this was in specific reference to the affidavit of the Honorable Steve
The second
Tashoni.
respondent, counsel, the second respondent is here in the person of
Honorable Stephen Tashoni.
Commissioner Tashobia, yes. I mean, I don't know. Maybe the other. All that I need to know is.
My Lord, you're
Are
referring.
you saying whatever other cost, inclusive of hiring counsel, they will not be entitled, or are you saying whatever other cost which can be permissible, if court is inclined to award cost, they would get it, but not for hiring
I'll
counsel?
give two answers in the alternative, my Lord.
Yes.
The first is that they would not be entitled to anything for having engaged in an irregularity and illegality. But in the microscopic event that you find they should get something exclusive of the instruction to advocates, then I would concede to transport to Commissioner Stephen Tashoni
No, that's not for us.
as a disbursement.
Councillor Lubega, you can wind up now. So what is your final prayer?
My final prayer,
Are you
therefore,
reiterating your earlier prayer?
to reiterate.
We are not taxing master.
No, my Lord, I am talking about the denial in principle that the taxing master should not even entertain a bill from the second respondent. Finally, my lords, we have mentioned that my colleagues who counsel for the first and second and third respondent have submitted, and I'm winding up, that that the provisions of Section 64 with respect to liability to...
You would begin by asking me for more time because you've eaten.
My Lord,
Even
may I
the
be
extra
granted
time,
half a minute?
Even the extra time. I'll give you 2 minutes.
Thank you, my Lord.
Please conclude. Half a minute, you would yawn and get finished.
With respect, my Lord, to the question of liability to pay costs as per Section 64, liability to order costs simply means this honorable court has the discretion. Yes. It is not mandatory, as submitted by my learned friend, Mr. Ellison Karuhanga, that where they say shall be liable to pay costs, it is mandatory. No, the word liability connotes that discretion. But even the word shall itself, it is not mechanically mandatory as he thinks or he seeks to submit. Authority, my lords, number 5.
What is mandatory in that one would be the liability.
There is nothing mandatory in that.
If you say shall be liable,
yes.
What is mandatory would be the liability.
No.
Not the cost.
No. What is mandatory?
Not the suffering of cost.
No. Nothing is mandatory in that, my lord. And the authority number 5 is a decision of this court, Sitenda Sebalu versus Sam Kenjuba, and the Electoral Commission. This honorable court, and my lords, I refer to to pages 50, specifically page 55, on the interpretation of that word has been made. And that's why, my lords, even in previous petitions, you have not awarded costs. I pray that you continue to exercise your discretion judicially.
Yes, because it is mandatory for court to exercise discretion.
Obliged, my lord.
On issue of cost.
Obliged, my lord.
The discretion, it is not something they come and say, we have awarded cost. We have not awarded cost.
May I rephrase that? Yes, it is mandatory.
Of discretion, it has got to be done judicially.
True, my lord.
You know the law on this.
And that's why I'm saying, my lords, and I emphasize the word that you continue to exercise your discretion judicially.
Thank you, thank you.
I so pray.
Thank you so much. Yes. Oh, sorry. I think there's a question from my learned
Council Segona.
sister, yeah.
There was an authority which was supposed to be roasted. Where is it in the process? Have you abandoned it?
No, my lords, after roasting
where
it...
Where is the registry? I think one of our...
My lords, after roasting it, it could not come back to the same suspiciously contagious hands of the lawyers.
But is it on the record?
I believe, yes. We filed it in the registry. And it is, if it is not there, my lord, it is in transit.
I think it's... Okay, that's the first question.
Yes, thank you.
Then I have a question for... Counsel for the second respondent. Counsel Karuhanga?
Yes, my lord.
You submitted that, and I'm glad it has been touched on in the rejoinder, and the court has also, talked about it earlier. That paragraph, the averments in the counsel for the applicant's affidavit regarding the issue of procurement are not within the personal knowledge of the person, the counsel, and therefore they should be struck out. That's what you submitted.
Yes, my lord.
So my question to you, my reading of averments in this application, and I think we had considered in this application, there are many other averments which fall in this category. Is it your position that court should simply strike them out?
Sorry, my lord, there are many other, I didn't get the...
Averments which have been made, and time does not permit us to go into them, which would seem to fall in that category. Shown by the one that they not being within the personal knowledge of the person deponing.
Yes,
so my question is that, is it also your submission that the court should apply the same standard to averments where deponents have deponed to matters that are not within their personal knowledge?
My lord, I think if I can just...
No, with respect, for example, to your client. Because I'm going to ask the same question to the second respondent. Is that your position?
Yes, my lord, our position is that the law governing affidavits is Order 19, Rule 3. In that particular affidavit, he deponed in his capacity as counsel for the applicant and said he knew about certain processes of the second respondent and did not show how he knew about them, where he had been informed about them. If there's any other affidavit that contains information where
From the
someone
respondent,
does not show
yes.
that he knows how where he does not disclose the source of his knowledge or how he obtained it, it would certainly violate Order 19, Rule 3 of the Civil Procedure Rules. I think the ultimate principle is where a deponent is giving us information that the deponent surely does not know, like Mr. Sekaja does not know, then we cannot rely on evidence that a witness giver surely does not know. As opposed to someone who said, I heard.
No. So you agree with me that that's a rule of general application. It applies to averments by the applicant, and so it also applies to averments by any party from, the respondents.
Yes, it applies. I'll speak for the second respondent, my lord. It would certainly apply. If you find evidence of ours, which our witness didn't know, my lord, please strike it out.
Thank you. So that takes me now to the Land Attorney General. You submitted, and this has been consistent, but in this application which is before us, if I may recall, that the averments of the applicant that he was restrained and could not prepare for his case were not true. And your evidence in support is the affidavit of the Land Deputy Attorney General, right? Which shows that the applicant was able to access, and you mentioned two in particular, his lawyer and his close associate. Okay? So my question is that if the applicant says I was not able to access whoever I needed to access to prepare for my case, was the Land Attorney General within the personal knowledge, okay, of who the applicant could have wanted to access to prepare for his case? Was that within his personal knowledge?
Thank you very much, my lord. If we look at paragraph 4 of the Honorable Kafuzi's affidavit,
yes,
in reply to the notice of motion, that is where he states that it is not true that the applicant's mobile numbers were disabled as alleged, that I know that the applicant's advocate, ex Turiamu C. Majofre and Zaki Francis, a close associate of the applicant, disclosed in their affidavits that they were communicating with the applicant on his mobile phone during the time when his movements were restricted. His basis was a disclosure in their affidavits.
Yeah, but you used this, the concern I have is that you used this this statement to make a general claim. Because the reason, one of the reasons the applicant is giving is that he gave the reasons why he couldn't, he's withdrawing, right? And part of it was the inability to access, which has continued to be, has continued to resurface. It resurfaced in the application for amendment. It resurfaced in the application for leave to file, extension of time to file additional evidence, and it has also resurfaced here. Is that correct?
The question of his restriction?
Yes.
Yes.
And your answer has been consistent that you are relying on the averments of the Land Deputy Attorney General. In one of them, a list of saying, yes, he accessed his lawyer, and he accessed a close associate.
Yes.
So my question is, that statement, the accessing the lawyer and a close associate, is that sufficient for you to make the claim you have made here that the applicant's averments about the effect of his, the restriction, the tender restriction, had an impact on, it's one of the reasons why he's saying he's withdrawing.
Well,
is there is it right to transfer, access to one person to say, because of this, therefore, he had access to everybody he wanted to access to prepare for his petition?
Well, all we were doing is that...
Because those are your submissions, Land Attorney General.
On which I have already told you, Learned Justice, that the averment in Honorable Kafuzi's, I've told you his source of the information, is the affidavit. And that was in response to the fact that he did not have contact with, to give instructions. So I'm saying that on the contrary, and by his own affidavit, he had contact. That's all that I'm saying.
Yeah, but does the law say that an intending petitioner, once they have contact to one or two people, that is sufficient? Is that the law? Can you cite any provisions
well, I don't
on which
know,
you are relying on to make that assertion?
But I don't know whether the law gives a number of how many there must be.
No, my question is, do you have any law to make the assertion that if a petitioner says, I was constrained and couldn't access whoever I needed to access to prepare for my petition,
well,
then the Land Attorney General says, no, you had access to two people. One, your team, which you instructed, and the second one, your close associate. Do you have any basis, legal basis for making those assertions?
Well, the basis that we have is that he had contact with his associates and his lawyers. That's the basis that we have.
Okay.
For example, he made some averments that his witnesses were abducted and harassed. Like I already said, he does not provide any evidence of who these persons were, of serious offenses. He does not give any evidence of the names of the people who were detained and therefore who made it impossible for him to present his case. Because had he done so, then we would have had the opportunity to controvert. That's all we are saying, my lord.
Okay. So, anyway, I think I've had the answers I needed. Thank you, Land Attorney General. So, yeah, thank you.
Any other person? Okay. Thank you, Landed Counsel, for the parties. We've been consulting within ourselves. We'll deliver a short ruling, which will be read out by Lady Justice Arach Amoko. Yes, my lord.
Thank you, my Lord Chief Justice. This is the ruling of the court. Upon careful consideration of the application, the supporting affidavits, the submissions of Land Counsel for the parties, the authorities relied on, and the law, and considering that the respondents have no objection to the application for withdrawal, leave is hereby granted to the petitioner as prayed, and the petition stands withdrawn. The reasons for allowing the withdrawal and the reasons and the determination of the issue, of course, shall be contained in a ruling to be delivered on notice. This ruling is signed by all members of the Decorum. Thank you.
Learned Attorney General, while my lords signed this document, the ruling, You brought up a very important matter that you'll be having a sitting, some forum with council, not just council here. I think you should include members of the press as well. The reason we have this fully covered is because this court belongs to the people. Everybody who cares to know what is happening in this court and has the opportunity should be able to follow, even from their sitting rooms, offices, their joint, and so on and so forth. So it's really important that for the good of the rule of law, for the good of due process, you really lead some discussions on our respective responsibilities, we as the judiciary, officials of the court like learned counsel, then members of the media, who have the responsibility to let the people know correct factual information on what is really happening in court. Because that's the only way we can do justice in all the matters that come before us. So in that setting, please widen the base. The catchment area should be wider. Thank you. Yeah.
Good morning.